Hi folks, my name is Greg McLawsen. I am the Affidavit of Support lawyer. I help green card holders enforce the USCIS Form I-864 and federal lawsuits. Let's talk about conditional residency, also sometimes conceptually called the I-751, when it comes to enforcing rights under the Affidavit of Support. Question is, does filing the I-751 or obtaining unconditional permanent resident status, do either of those terminate your rights under the Affidavit of Support? The answer is absolutely not. This is one of those questions where there's just a really clear answer. So let's drill down a little bit and talk about why. Conditional residency is this concept that it's sort of like a probationary status. When you have residency status that's based on a marriage that's shorter than 2 years in duration. So that means less than 2 years from when you got married to when you get your green card. You end up with something called conditional status. The idea is basically that in the 2 years following your residency, you have to come back to USCIS and demonstrate that you are, in most circumstances, still married to the US citizen. The idea basically is to have a check and balance on ensuring that it was a legitimate relationship and that you weren't getting married just for a green card. So at the close of that 2-year period of conditional residency status, you have to file the I-751. And this is normally done with the US citizen as a joint petition to demonstrate to USCIS that you're still together. If you are not married at the end of that 2-year period, or you're in the process of getting divorced, you can file the I-751 by yourself as what's called a waiver petition. And the primary grounds are either that you're in the process of getting divorced, but the marriage was legitimate, or demonstrate that denying the I-751 would result in hardship to you, or that you were abused in the marriage. And this isn't a video about how to file the I-751, but that's the quick overview. When you go from conditional status to an unconditional status, which is when you have your 10-year green card, you aren't, and this is a little bit technical, but you are not transitioning to a new form of residency. Instead, you were already a resident, and the only thing that happened is that conditional status, that probationary status, is removed. So it's not that you went from legal status 1 to legal status 2. It's that you had one legal status, and this kind of feature of it, the conditional status, is removed. Why is that important? Because when it comes to the Affidavit of Support, the federal regulations are very clear that there are only 5 events that end a sponsor's obligation. One of them is if the sponsored immigrant loses legal status and departs the United States. But when it comes to the I-864, there is nothing in the regulations that says going from conditional residency status to unconditional residency status terminates the Affidavit of Support. There's absolutely no legal basis in the regulations to say that that terminates the Affidavit of Support. And more fundamentally, there is, again, no loss of that original status. So that original residency blanket that wrapped around the foreign national remains there. It's just that it becomes unconditional instead of conditional. This is something that I see raised very, very occasionally by defense attorneys. Usually you don't get immigration attorneys arguing about this when it's an immigration attorney representing a sponsor. Usually they have enough sophistication about the immigration statute that they understand the background that I was just discussing in terms of the nature of conditional residency. But once in a while, if you have a civil litigation attorney representing a sponsor in one of these lawsuits, they'll kind of frankly get confused about what conditional residency status means. And they will rush into court and say, aha, your client is now no longer on that same status that they were when my client, the sponsor, originally signed the Affidavit of Support. And you have to say, no, they are on that same status. It's just that the conditional nature of that status has been removed. Now, everything that I was just saying about the continuity of status and the continued enforceability of the affidavit of support, all of that is true even if the I-751 is filed not with the sponsor, but as a waiver petition. So in this scenario where the foreign national is getting divorced from her sponsor during that 2-year transitional period, and she has to file the I-751 by herself, even if she goes that route, that doesn't change anything about the enforceability of the affidavit of support. And by the way, this is a really, really common scenario for me to see in my practice, because the sad fact of the matter is that tends to be a period when unstable marriages do fall apart, is that, in the 2-year or so range. So it's really common to have somebody who came to the United States on a completely legitimate marriage that just didn't work out. Very common to see abuse in those scenarios. And so the foreign nationals finally had enough and they're separating from their US citizen sponsor. If that foreign national has to go the I-75 waiver route, the I-864 absolutely remains enforceable. And again, that's a really common scenario where we see enforcement really as a very important tool for this foreign national, because under the law of a lot of US states, that person isn't going to qualify for alimony or spousal support because it's been a relatively short duration marriage. But the duration of the marriage does not matter when it comes to the rights under the affidavit of support. And the financial rights are the same regardless of how long the couple has been married. So bottom line, I-751, whether it's filed jointly with the sponsor or alone as a waiver petition, under no circumstances does that impact the enforceability of the affidavit of support. And if you watch these videos, you'll hear that there are some issues that are like unsettled and different courts might decide them different ways. This is one of the issues where I think there's just a really clear legal answer, and I've never seen a court get this one wrong. So black and white, I-751 does not end obligations under the affidavit of support. Hope that's helpful. If you have questions about the enforcement of the affidavit, feel free to jump into the comments. If you would like an individualized case assessment of your rights under the affidavit of support, feel free to reach out to us at soundimmigration.com. Cheers.